Good afternoon, everyone. Welcome to our first CSBARS meeting of the year. At this time, I call for roll to be called to establish a quorum, please.
Dean Clancy.
Present.
Dean Keller.
Present.
Dean Leal.
Present.
Dean Marshall.
Present.
Dean Park.
Present.
And Dr. Wilcoxon.
Present.
We have a quorum.
Okay, great, thank you. This time when we open the floor for public comment, if to any public attendees, I'd like to remind you of a couple of changes that were implemented last month to make public comment more accessible. First, there's a dedicated email box that's been set up for CSBARS. Address is csbars@calbar.ca.gov. This is also noted on the agenda. So public comment received here will routinely be forwarded to all CSBARS members, if there is any. Second, folks can also sign up in advance to give public comment, typically limited to 2 minutes, using the link to the form on the website. For this particular meeting, there was one sign up, but the person did not leave us with any way to recognize them, such as a name or last 4 digits of a phone number. If that person who signed up is here to give public comment, or if anyone else wishes to provide public comment, please raise your hand to be recognized. You can do that via Zoom under the Reactions tab, or if you're on the phone using *9. Please keep in mind that public comments are limited to 2 minutes. Is there any public comment today?
Yes, Dean Keller. And to clarify, you can use the new form to sign up for public comment, and those comments will be taken first, but you can also raise your hand at the meeting, even if you have not signed up in advance. We do have several individuals making public comment. The first one I see on the list is Todd Hill. I'd like to recognize Todd Hill.
Good afternoon, all. Happy New Year for those who I've not been able to address since the passage of the new year. And thank you for the opportunity to speak. I will first start with, I do think that 2 minutes is very difficult for a layperson to coherently bring a grievance or an issue. I think that, again, in the interest of protection of the public as the first priority, it seems very strange when there's really tend to be very few, probably less than 20 minutes for most meetings of public comment, that there is such a war, it seems. And I say that sort of euphemistically, but it seems like there's a war against it. And again, I've said before, I think that is because it is hard to evade or invoke plausible denial in this forum. So I think it's one of the few forums that actually, from a public perspective, yields that benefit, and that benefit is of import, as we see today. I also did submit public comment, and I did actually submit, I thought I completed the form completely, because I suspect it was me using the form. I like to use the forms. Well, it's not a pleasure, I just use them because, you know, at least there may be some record that goes someplace. So from that perspective, I've been very disappointed with CSBARS for good reason. My grievances are real, they're visceral, they impact me daily, they impact my family daily. And I expect them to be addressed.
30 seconds remaining.
Okay. I also think that if you have a 2-minute issue and you interrupt somebody for 3 or 4 seconds, that's not appropriate. But and I know that is your job. It's not a personal attack. It's just it's meant to disrupt, and it's meant to distract. It's not useful. I hope that you guys will endeavor to take up my issue. I move forward no matter what. Thank you.
Thank you, Mr. Hill. Is there additional public comment?
Yes, please recognize Rev. Frank. And Rev. Frank, right now your microphone is muted. I'm going to ask to unmute to allow you to be able to speak.
Oh, it got covered up by one of the messages. My apologies. For those of you, hang on, who haven't seen the website I built on my criminal complaint against Vanessa Holton, you can go to vanessaholton.com. I actually finally got the San Rafael Police Department after 2 years to close out the false police report she filed. And the date that she filed it was the 23rd of November, 2020, which was the day after I filed the state bar complaint against her, which I say, according to California law, committed a felony in threatening me with the San Rafael police. But of course, because we can't trust you guys, and it's just, you know, if you hide your head in the sand, then who really cares if somebody broke the law, right? As long as it's not you guys getting charged. Look at the site, vanessaholton.com. You'll see the letters I've gotten from like Risa Marie, who tells me that when I made a complaint against Donna Hershkowitz 2 years ago, then I complained that that was done by Larry DeCello, which was Vanessa Holton's boyfriend, probably in college. Well, at least they went to the same college and they graduated from the bar about a year apart, and they've worked together for 40 years. I didn't think it was appropriate that he was the one handling my state bar complaint against Vanessa. And yet Risa Marie says now that, oh, Donna was excused and recused herself. So even when I told them I wanted it done, again, which I still have outstanding state bar complaints that they're not handling, that, you know, it just gets to be pathetic to the point of, again, how do we trust you when we file complaints and you ignore evidence, declare attorneys, and then you turn around and hide police reports? And if you look on Vanessa Holton, she did it on government time using government stationery
30
and
seconds.
used her staff to file it. And Leah is ignoring my wonderful Freedom of Information Act requests. So if you could pass on to her, I've updated my website, leahtwilson.org. She should take a look at it. By the way, the middle name is Taboo, not Tamu, on leahtwilson.org. So you guys have fun, look at the websites. And again, you guys need to change up the state bar to where they don't handle the state bar complaint intakes. That should go to the judiciary to make sure that this can be handled on a real level, not who's your buddy, who's your friend going to do a favor for you. Again, if you don't change that up, nobody in the state of California is ever going to trust you guys. And that is sad. Okie dokie.
Okay, thank you for your comments. Is there any further public comments today? I'm sorry, you're on
Oh,
mute.
so sorry, I'm muted. There's no further public comment. And just to emphasize, those who wish to sign up for public comment at future meetings, there is a form that people can sign up on, and we'll recognize you by the name or handle or digits from a portion of your phone number that you list, or in order to receive written public comment, that would go to csbars@calbar.ca.gov. We did not receive written public comment for this meeting. So if you would like to submit public comment, please do submit it to that address at any time, and it will be forwarded to the CSBARS. Thank you.
Okay, thank you. And for anyone wishing to get more information on the scope and the role of CSBARS, the Committee on State Bar Accredited and Registered Schools, I'd refer you to the CalBAR website, which describes the role and scope of this committee. So that concludes our public comment. I did want to mention with regard to future meetings that the CSBARS schedule for the year has been posted on the CSBARS committee page. Also, applications are available for those who might be eligible to seek to serve on CSBARS starting in fall 2023. If you are interested and eligible, you can find the applications on the committee, commission, and sub-entity page of the website. So the applications are not on the CSBARS page. They're on the committee, commission, and sub-entity page of the website. With that, let's move on to the approval of the minutes from the November 30th, 2022 CSBARS meeting. I know these were posted. Is there a motion for approval of the minutes from that meeting? And if so moved, please identify yourself when you respond.
This is Michael Clancy. I move that they be accepted, approved.
Okay. Thank you, Dean Clancy, for the motion. Is there a second?
I can second. This is Jessica Park.
Okay, thank you very much, Dean Park. Can we proceed to a vote?
Dean Clancy,
Aye.
Dean Leal, Dean Leal,
Aye. Can you hear me?
Dean Marshall. Yes, thank you.
Aye.
Dean Park,
Aye.
Dr. Wilcoxon,
Aye.
and Dean Keller.
I support the motion as well, though my vote is not necessary as chair since the motion passes regardless. Thank you. Right. So up next is our report on the Committee of Bar Examiners planning session related to law school regulation. So as you may recall, I attended the last CBE meeting and provided feedback as we discussed, summarizing the very high level preliminary feedback on potential project referrals. At that time, most of our discussion and therefore my report to the CBE centered on metrics related to law school performance and what that might entail. I summarized our discussion for the CBE. At that time, there was no follow-up from the members and no discussion specific to those metrics. At the December 2nd CBE meeting, the members had a planning session revolving around BAR's strategic plan goals, which included a brief discussion of law schools. So I wanted to report back a little bit on that. Regarding ed standards, having a meeting with institutional accreditors to better understand their approach to standards was mentioned. As an aside, Chair Kramer floated the idea of reconsidering one of the longstanding goals related to mandatory accreditation for registered unaccredited schools. Although it was an agenda item, he did note that the goal had been on the list for some time and was repeatedly deferred, and mentioned that he thought if implemented, it might have very negative effects on some schools. So Chair Kramer mentioned that the CBE might want to discuss this in the future, perhaps in connection with the BAR's access to justice goal. Specific to strategic plan goal 2, regarding the protection of the public by enhancing access to and inclusion in the legal system, there were 4 items identified as part of the work plan. 1, ensure law school compliance. 2, revise unaccredited law school rules. 3, promote engagement with law schools. And 4, review and approve law school retention analysis. There were also 3 potential trainings mentioned related to engaging partners. 1, potentially reviewing non-JD programs and their role in law schools. 2, related to institutional accreditation, as I just mentioned. And 3, possibly some sort of workshop on trends in legal education, possibly including online education. So those are just some very, big picture items that they laid out for potential future discussion. At Friday's upcoming CBE meeting, the CBE will be asking for CBE members to participate on the CBE's Rule Review Committee for the unaccredited law school rules. Those members being in addition to Ed Standards Chair Dr. Wilcoxon and Vice Chair Jim Epting. So the CBE is planning to send revisions to the Board of Trustees at its November 2023 meeting, according to their current timeline. So if you have suggestions or particular areas of interest relating to revisions to the unaccredited law school rules, I encourage you to please send them to Natalie Leonard. If you have specific edits in mind, feel free to send her on exact language. It's most helpful if you can send your comments and suggestions as soon as possible so that she will be able to have that information as the process goes underway.
And for members of the public, that feedback is also extremely welcome, and you're welcome to use that public comment email address, and that information will be shared with everyone working on the rules revision.
Okay, great, thank you. Right. So that concludes the chair's reports. We can move on to staff reports.
Thank you, and we'll begin with a report from Audrey Ching regarding the professional licensure program.
Thanks, Natalie. Thank you, everyone. I think most of you probably know this, but I'm just going to recap what happened in December with the provisional licensure program. So our Board of Trustees at the State Bar sent recommendations from their December meeting to the Supreme Court with different options for those in the what we would say the original program, which were the 2020 graduates, and then the expanded pathway program. So on December 23rd, the Supreme Court issued an order, which you can all read on our website and the court's website, with these what they kind of picked out of the options, actually, and some of their own amendments to what we had put forward. So some of the highlights: the original program, those 2020 graduates, that's extended until May 31st, 2023, if you were admitted to the program by December 31st, 2022. So by May 31st, provisionally licensed lawyers in the original program must have completed the following. They must have a passing MPRE score, have an active positive moral character, complete the new attorney training program, and have a supervisor committed to supervise the provisionally licensed lawyer through the end of 2023. So if all of those requirements are met by this coming May 31st, they can continue into the program through December 31st, 2025. So that's a lot of changes there to that original program. And then with the expanded pathway program, that program is reopened. The application has been reopened to that group. So that was, you qualify to be in the expanded pathway program, which is the pathway to licensure, if you had a first read score or final score between 1390 and 1439 on a bar exam administered between July 2015 and February 2020, which is when we changed, you'll remember, changed that cut score to 1390. So this order extends the participation for the pathway program, the pathway to licensure, through December 31st, 2025 for all eligible participants who apply by December 31st, 2023. So by the end of this year. We opened applications based on all this information received from the court on December 23rd. We opened all those applications back up on January 4th. Are there any questions? I know I just said many things. Okay.
I have one question.
Sure.
That is, I'm assuming that notice went out from the bar to all of those people who are now eligible to get involved in the program. I'm
Exactly. And
assuming
that was part of the reason why they wanted to reopen that pathway to licensure for that group between July 2015 and February 2020, because in our survey of eligible folks, there was some of them didn't know. So we did, the court opened it up again. We sent notice to all those that we have in our database, the emails that we had. So I guess if anyone's listening and you might have changed your email address since July 2015, or if you're alumni, if you have some kind of alumni blast that you want to send out that could amplify those messages, I think that would be really helpful.
Thank you.
I think it's back to me also, right, Natalie?
Yes, bar features, please.
Okay. So we've talked about this, I believe, at one of our CBE meetings, but maybe not here. So I wanted to kind of give you an update on what we're calling the bar exam features experiment this year. So we, as you know, we've had the Blue Ribbon Commission for a couple years looking at the future of the bar exam in California. The Blue Ribbon Commission has recommended that California develop its own bar exam based on the California Attorney Practice Analysis recommendations. So that's kind of a separate bucket, but because of this, looking at redesigning the bar exam, we applied for a grant through Access Lex to look at different bar exam features and see how those features might affect different subpopulations. So specifically, we're looking at time, how much time per question, remote versus in person, and closed versus open book. Those are sort of the main categories of features that we're going to look at through this grant. And we are exploring, we have an internal team. Obviously, we have the grantors at Access Lex, and then we have an advisory group, 2 members from CBE, an accredited law school member and a registered law school member. We're meeting with that group in February after we're going to propose all the different options that we have on how to conduct this experiment, because we want to have, be able to have a wide variety of participants from this year's applicant pool for different bar exams. So we will let you know more when we have more to report, but just want to let you know that that is in the ether, and you will be hearing a lot more about that over the course of this year.
Thanks, Audrey. We also have several just recent developments to go over with the members, and I'll take those. So just quickly, first of all, thank you to all of the schools who turned in your annual reports. We are reviewing them now, and the topic that we are looking at is the demographic retention data that was part of the Excel spreadsheet. So for some of the schools, we've gone back when we have specific questions, and we really appreciate the collaboration and response that we've gotten from the schools where there are questions. So thank you. We look forward to continuing to collaborate, and we appreciate your prompt response as to those. Okay, thank you. So that's what I have, unless there are any questions on that topic. Okay, I think we're ready to turn to our discussion item. Dean.
Actually, I think Dean Leal had a question or comment.
Oh, sure.
Hi, yeah, thank you, Madam Chair. Yes, Natalie, just a quick question. I know when we were working diligently to get a report done, we ran into technical issues with at least one of the spreadsheets. If I remember correctly, it was the demographic information regarding faculty, and no matter what we did, and when we plugged in numbers, it would automatically calculate zeros, and we tried every which way possible, and we gave up. And so we're really, did other schools report any issues with the calculating function of the spreadsheet, any of the spreadsheets?
Not specifically that one. I'd be happy to follow up with your registrar if you'd like. And if schools are having difficulty with the forms, you're welcome to contact us in the meantime, or if it's close to the deadline, but you were able to provide the information in another format, that will also be fine. Okay. And in this case, your school did in fact do so.
Yeah, I know. I think that's right. But and again, we got it in early, but time pressures prevented us from, and I figured you and the rest of the staff were pretty busy. So this is, I thought, a good time to bring that up.
No problem. I've made a note of that, and I will go ahead and review that sheet.
Yeah, it may have just been ours. So, okay, thank you. Appreciate the information.
No problem.
And Dean Park, did you also have a question or comment on that?
Yes, before we move to discussion topics, I had a few questions about the reports.
If there are specific questions as to pinpoints, it might be easier for us to discuss offline just because of the numbers of data, but global questions, sure. But
Yes.
completely up to you either way.
Oh, no, thank you. Yeah, I don't think I'll be going into one law school's particulars or anything like that, just more general questions. So from the chair's report, thank you so much for your update, Chair. I have a question about what's being asked of CSBARS members or the public in terms of sending in inputs related to the unaccredited law school rule and guideline revision. And of course, as an unaccredited law school dean, I'm very interested in this project and how it can impact stakeholders in this area. Is there, any parameters as to, these needing to be higher level comments or a time frame? So I understand as soon as possible, and I understand, it can be specific edits or exact language, but I'm just curious if there's any other parameter behind kind of the ask being made.
Sure. Dean Keller, would you like me to take that?
Yes, please.
Okay, so the goal is to present a proposal that's already passed through the CBE to the Board of Trustees in November. So passing something over the summer to the CBE and then to board in November. This Friday, there will be a call for volunteers from the CBE to be working on the project. So we expect to be able to bring a more specific timeline and parameters back to the committee, to CSBARS in March. But in the meantime, it would be very helpful to know the following. If you have a particular interest in working on a certain area or providing feedback in a certain area, that would be helpful to know. And just generally, both global and specific comments are welcome. There'll be a format to slot them into, but if we know the general ideas that are on the CSBAR's mind at this time, it'll help to create the best schedule possible. We have been tracking and we've been asked to review the past CSBARS agendas as well as CBE agendas for questions, comments, and concerns that have been raised over the last 3 years for the unaccredited rules. But it would be helpful to have that general feedback now, and then there'll be more of a timeline in March. Does that help?
Yes, that is helpful. And I think especially, of course, well, there's many types of stakeholders. I think if I have that to share with unaccredited law school deans, that'll be great. And they can kind of understand the timeline of what's being discussed this year. Thank you.
Great. And at this point for today, the rules are not agendized for discussion. So we wouldn't be talking here about the substance of the rules, but we do definitely encourage submissions.
Great, thank you. And then I had a second question, and it is my last question about the bar exam features experiment. And I just was curious about the mention of, there is going to be this internal team, a group meeting in February 2023, and this chance to look at the applicant pool. So I was just curious about that comment. When you say applicant pool, as you're exploring these bar exam features, is it future bar exam takers that are potentially going to volunteer for different modalities of the bar exam that's going to be studied?
So I was thinking about the applicant pool from the upcoming exam, the July exam, right? Because it's the February exam is really soon. But so thinking
Right.
about that applicant pool and how to get the broadest, most representative sample, in terms of the statistical significance of what we need to look at the features. And that's what we're all discussing, like what's the best way to get the best kind of, broad pool that will give us really good data on those future decisions.
Great. And is it this might be a little bit early to ask, but is it a matter of the applicants in that pool potentially volunteering for different modalities, or is it you know, maybe naturally in terms of what they need for that July bar exam, sort of studying?
No, so it will be separate. It won't be part of the bar exam itself, right? So it's just, it's looking at different features that are not going to be, we're not going to alter the current bar exam. There's a whole lot of reasons about we are not, you know, able to alter the current bar exam in process, right? So, but it will be, yes, most likely it'll be volunteers from, yeah, we're not going to like randomly select people and tell them to do the experiment. Anyway, it is kind of early days, but we will be asking for volunteers. The question of is how we're going to ask for volunteers. How much will the law schools need to help us? Probably a lot. Get the volunteers. When are we going to like time that? Is it going to be on Saturdays? Who's going to get to be remote? I mean, there's a lot of like decision-making points along the way that I will be happy to report as we make some decisions. But yes, looking at the July bar exam applicant pool and trying to figure out when the right timed experiment will be.
Great. And I think I got a lot of clarification there, like this type of experimentation totally separate from the July bar exam. So thank you. Thank you for that.
Not separate from the people, but yes.
Yes.
Yeah.
Okay. We also have a hand up from Dean Leal.
Yes. Can I make a suggestion? You know, the comments about providing input, which is what we all want to do in terms of perhaps revising and changing the unaccredited guidelines and rules. I would really appreciate a conversation of the CSBARS for you know, just to help us perhaps formulate where the committee ought to be headed. And for instance, I'm looking at Dean Clancy and knowing that his school operated very successfully for many years as an unaccredited school and then made a successful transition to a CALS and now is more, you know, continuing to succeed under the CALS rules. It would be, I think, particularly helpful for me and perhaps with Dean Park, with schools that are always looking ahead, and we, you know, we hear Chair Kaplan's words ringing in our ears with regard to our pathway toward accreditation is to get just a discussion of where the unaccredited rules and guidelines could and should be strengthened or changed, aligning them with the CALS rules to make that transition easier. So, you know, the kind of expertise and input that we would receive individually as schools, but collectively as CSBARS to then advise the committee, I think would be extremely helpful. So if we could have an agenda item for a discussion and maybe submit things ahead of that for that discussion at CSBARS, I think that would help us deepen and strengthen any recommendation that any of us could make to the committee.
Thanks, Dean Leal. And may we lower your hand, Dean Leal, with your permission? I just wanted to make sure you finished your comment. Thank you so much.
Yes. All right, thank you. Let's move on to our discussion item on the agenda today, which is further discussion of best practices for preservation of student records when a law school closes. For new members of the committee and members of the public, I'd like to briefly provide some context for this item. Some time ago, the CBE referred to CSBARS to study record-keeping practices to ensure the protection of student records. This concern arose, as I understand it, from a potential situation where there's a sudden closure of a law school, where a custodian of the records is not available, or the named custodian cannot be found, or otherwise is unavailable. And so, of course, we want to be able to figure out ways to address that sort of situation without unduly burdening schools. At our October meeting, members of CSBARS presented research on some of the different approaches, particularly the BPPE approach. And we generally discussed whether there might be other possible areas of research that CSBARS or staff might look into. To get us sort of back into this discussion mode on this topic, I've asked Natalie Leonard to present a brief PowerPoint regarding the issue, and I've asked Dean Park to participate in that, to summarize the research that was previously presented on the BPE, so we're all sort of up to speed as we move on.
Thanks, Dean Keller. So I'll turn to the PowerPoint in just a second. Many of you know that in the case of a closure of an ABA school, very often that school is part of a larger university. And as a result, the university itself continues on and serves as the custodian of records. So we're just doing a review of the way that records are handled in schools that are standalone schools, and the safeguards that are currently in place, and if there should be any changes or updates to make sure that best practices are being used. I'm going to go ahead and share my screen. So that we can talk a little bit more about it. Just a second. Devin, how can I make the ribbon go? Here we go. Okay. Can everyone see my screen? Perfect. Okay. So right now, unaccredited law schools, which is where we're focusing on at the moment, forward their list of students to the state bar within 60 days of enrollment. And so after every term where there are new students enrolled, whether they are for 1Ls or transfers, we get a list from the schools. And then as part of the annual report, both the unaccredited and accredited law schools forward lists of new admittees to the state bar as part of their annual report. And then finally, from the student perspective, when a law student begins law study, if they intend to license in California, which they certainly would in the case of students that are at registered or accredited schools, they're required to register with the state bar within 90 days of beginning law study through the applicant portal. So when we began the discussion in the fall, we started to look at a few different questions. We thought it was time, after not having done this in a while, to survey how other groups were handling this. Groups like the Bureau of Private Post-Secondary Education, which handles a lot of the non-legal education in California, and you'll be hearing more about that from Dean Park, possibly expanding this to some of the regional and institutional accreditors, some of whom are accreditors of schools here or schools who may be out in the audience. To think about possible escrow options, such as working through the law school data service, where many ABA schools and some other schools also lodge their transcripts right now. We're interested in the unique challenges when the school is a standalone school, much as I talked about before, and how it can create a relationship with a long-term custodian after closure, and also how the state bar can support schools in tracking and requiring student registration and encouraging students to keep that registration updated for reasons we can predict or reasons that come up later, such as the Provisional Licensure program. We also would like to look at whether or not it is feasible for law schools to share copies of ongoing student records with the state bar on an ongoing basis as possibilities. And this group may also have other ideas about how this data should be handled. So at this point, I will turn it over to Dean Park to think about how it's being handled right now at the Bureau of Private Post-Secondary Education.
Thank you, Natalie. Happy to speak on this topic. I was part of the subcommittee groups that worked on the questions that appeared in an earlier slide. So I'm happy to cover some of what was discovered in my subcommittee with Dean Clancy about what BEPI has related to school closure. So in our research, and all of this really is in our statutory research done on the BEPI website, we looked at what they required for a closing institution And the first code here, section 94926, specified the need for a closing institution to provide a closure plan, which should include a plan for disposition of student records. And we saw that in terms of how Beppy was talking to institutions in California about closure, that they kept mentioning that need for an institution prior to closing to provide the Bureau with pertinent student records. So here there's more specifics in 94927.5a, including transcripts in hard copy or electronic form as determined by the Bureau pursuant to regulations adopted by the Bureau. And just for some context here, this section has, one part that really was intended at that time, I think, to cover unaccredited institutions. Since then, Beppy definitely has changed pathways for how their registered institutions should attain accreditation. But at that time, it was contemplated there would be schools that did not have accreditation. But there is a part 2 for an institution that is an accredited institution. So prior to closing, those types of institutions should provide the Bureau with a plan for the retention of records and transcripts approved by the institution's accrediting agency. And that provides information as to how a student may obtain a transcript or any other information about the student's coursework and degrees completed. And as you can see, in one case, it's really a handover of the records. In the second case, it is a plan. So that was an interesting distinction that we found. Going to the next slide, we definitely wanted to be sure that what we were looking at really could apply to law schools in California, whether they were standalone or of different types. And so the California Education Code 94927.5b really does clarify this through some reading through the cross-references. So subdivision A applies to all private post-secondary institutions, including institutions that are otherwise exempt from this chapter. And the emphasis is really added here. This is going towards the scope of what the school closure provisions should apply to, that it may apply to private post-secondary institutions, including institutions that are otherwise exempt from BEPI regulation. And going into the relevant section, so section 94874, we do see that law schools are mentioned in subsection G. So a law school that is accredited by the Council of the Section of Legal Education and Admissions to the Bar of the American Bar Association, or a law school or law school study program that is subject to the approval, regulation, oversight of the Committee of Bar Examiners pursuant to those relevant sections of the Business and Professions Code. This is a category that does have exemption from BEPI rules, but when it comes to this school closure provision, even though this category might be otherwise exempt, they are not exempt from that school closure provision. So we also looked in the subcommittee for just other mentions of items. So we saw not in the California Education Code, but in the Code of Regulation, which can be used to interpret the statute. So that it does mention, again, a plan for disposition of student records. And I believe if we advance to the next slide, this will just include more of what we saw in the California Code of Regulation, that there is, and these are used typically to clarify or interpret the statute. So that there is a set maximum time period for how long student records and transcripts need to be retained by an institution. And we just included that language here because we thought that was useful. In addition to permanently retaining a transcript, as required by section 94900B of the code, the institution shall maintain for a period of 5 years the pertinent student records described in section 71920 from the student's date of completion or withdrawal. And so this is language that continues to be there. And when I did a recent recheck of this, just to make sure our information is up to date. I still see that language there. Notwithstanding B1, which is what I just read, the BEPI, oh, sorry, not BEPI, the CCR section that I'm referencing, they do make it very clear that regardless of that part 1 I just read, the institution shall maintain records relating to federal financial aid programs as provided by federal law. And that carve out makes sense. They want to make sure to regulate student records and how long they need to be kept, but they want to make sure that those participating in federal financial aid programs have their student records kept as necessary for participation in those programs. So that really is the last of just looking through statutes or regulations. The last slide just covers a BEPI website. And I thought this was useful because this shows some of the implementation side for BEPI, especially how they handle student records that may have been passed to them from closing schools directly. So as you may remember from a prior slide, there was that part 1 where prior to closing, a school had to hand over those records to BEPI. But there was a part 2 of that where for an accredited institution, it was going over a plan of closure, but not necessarily handover of records. So we think for that first part, when the closing school needs to hand over records to BEPI directly, they handle it in this way. They have a website that's concerning transcripts and student records, and it is a contact point for students to reach out to them and request a transcript from a closed school. As well as there's a directory of closed schools there where I think more can be selected in from a public user in order to access records. So this is the language regarding transcripts. In the event of a school closure, the school is obligated to provide a custodian of records, someone a student may contact to obtain a copy of their transcript. In some cases, a closed school will provide copies of transcripts to the Bureau. So I included the HTML here, and that remains the same as when we looked at this issue before. With that, happy to pause here and take any questions about what our subcommittee had generated.
Great, thank you so much. Does anyone have any questions? Or Dean Clancy, I know you looked at this closely as well. If you wanted to add to that, please do so.
I do have a few comments. First, I wanted to point out that at our last meeting, we talked about the fact that the BPPE was set to sunset on January the 1st of 2023. So if that agency had gone away, then we wouldn't have the BPPE to look to help us with this issue. But I checked yesterday and I found that, in fact, Senate Bill 1433 was passed. Governor Newsom signed it on September 25. So the BPP has been extended to January the 1st of 2027, which is, I think, a good thing overall. As I understand the main question that is going to be before us, and maybe I've misunderstood it, but it seems to me that the main question is, should records for our schools and transcripts be turned over to the state bar on an ongoing basis, or instead, when there is an imminent closure or some concern, in other words, some triggering event, should the school give the state bar records or transcripts? And as I consider those two questions, or that question with two parts, I wonder why, if the BPPE is already tasked with the responsibility of taking records and transcripts from all schools, including California law schools, why would the state bar be getting involved in it? So that's one question that I have. And then the second question is, does the BPPE actually do what it says by its regulations that it's supposed to do? And I'm going to argue that the answer is not always. I have some concern there, and I've been involved with issues twice in that regard for people who've come to me to say that they had attended BPPE regulated schools. The schools went out of existence. They needed transcripts and couldn't get them. So I found, as I tried to help, and after I contacted, or when I contacted the BPPE, that it is not diligent in its effort to get transcripts and records from schools. They rely on a promise that a custodian will keep the records, but then it seems to me, at least in the two instances that I was involved in, they lost track of follow-up there. So I think that somebody from the state bar should contact the BPPE to get specifics on what it is they're actually doing to comply with that regulation that says that they are responsible for this issue overall regarding protecting students from closure. That is all I have in the way of commentary at this point.
Okay, thank you. I think that's definitely one of the things you mentioned is kind of a through line consideration of any of these points is, are we talking about an ongoing obligation, an obligation that kicks in when there's a triggering event, or something similar to what we have with BPPE when it's just at the point of closure? Yes, Dean Liao. Oh, sorry, Michael, go ahead.
Oh, okay, thanks. I just happen to think that there's one other comment that ought to be made here for our consideration, and that is regarding liability. I think the state bar needs to be concerned about the extent to which it would be liable if, for instance, it takes in transcripts, it takes in possibly other records in addition to transcripts, and somehow there's a breach of the system where these items are held. What is the responsibility in that regard? Certainly the schools have responsibility when there's a breach, but I'm just wondering if the state bar ought to take on a similar responsibility, especially when there's some other governmental agency that's already been tasked with the requirement of taking these records. Nothing further at this point.
Okay, thank you. Dean Liao.
Yeah, I actually have a question as to what has been done most recently. I think one of the registered schools as of 2 days ago just had lost its registration after a lengthy process, hearings and time given to try to keep the school in good standing. And so the question would be, what, if any, requirements did the committee place on that entity, knowing it was closing it, that they preserve, protect, and perhaps provide access to their transcripts for their students? Because I know I've received contact already from my school of students looking to transfer, and so it hasn't gone beyond an initial contact. But I have a question of who I would contact in the event that, or who they would contact, trying to get their transcripts. So since the state bar and the committee of bar examiners is one of the primary forces behind schools closing, I guess the question is, what has recently been done in terms of requirements or an agreement with the entity that's closing and yet has custody of the records, the transcripts and records that they've had for quite some time?
Sure, thanks, Dean Leal. I'd be happy to take that. So in this case, there is a surviving university in the case of that closure. And so that university is the custodian. They also forwarded a set of transcripts to the state bar regarding the recent students that the state bar has. So there are two options. And the current students and recent graduates were advised of the custodian that was advised also in a public forum of the CBE meeting and part of the CBE motion in addition. And we'll be following up with those students as well.
Well, that's great to hear. And I guess the question, that's standard operating procedure now with regard to schools that are ordered to, well, in the case of a school losing its registration, actually going out of business.
So then just a quick follow-up, then it seems like if we think of this kind of as a funnel, there are the schools for whom this does not seem to be an issue. Then there are schools where there might be some sort of triggering event, being put on notice. And then there are schools that are actually, nearing the process where they might lose registration or accredited. status. So we have all of those points where, you know, the CBE may be able to impose an additional requirements, you know, on a specific school based on apparent need. So is the issue that the schools that either don't comply with that or say they're going to comply and don't, and that's why we're trying to think about sort of more preventative measures?
It's not so much an issue, it's more of just a review of what's in place right now to see how it's going and could it be better? You know, could it be continue to be enhanced in the future? The closures that happened recently were both closures in which in one case there was a surviving university, in another there was a merger and a surviving entity, and they were handled pretty smoothly in the way that I just described to Dean Leal. But even though things are going smoothly, it's always good to look back and see if things can be further improved.
Okay, thank you. Okay, I think that was simultaneously. So I see Dean Marshall coming up first and then Dean Park.
To maybe address what I thought I heard Clancy mention and suggesting, and you correct me if I misunderstood, a question of why not stay with the BPPE as opposed to the state bar, why complicate things? And that suggestion anyway resonated differently with me, and it seems to me that it's more complicated if we rely on an external regulatory body that perhaps isn't as invested in the relevancy of a law school transcript. So from the perspective of the state bar having some kind of connection link or protective umbrella archival system, it seems to me that's the most relevant entity with regard to some kind of best practice should that triggering event occur.
Okay, thank you. Dean Park.
This is just me looking back at the time that we last discussed this issue and trying to think over whether there were any options that really opened up since then. I believe when we last discussed this issue, there was going to be possibly an exploration of are there vendors out there that could be looked into further that handle record retention or could handle it at a level that would be suitable for, you know, a regulating entities requirements. I also remember that there could possibly be some outreach to BEPI directly, and I just wanted to check, you know, were any options further explored, or was there any dialogue with BEPI directly
Sure.
as part of exploring this issue?
Sure. So with respect to commercial vendors, the issue is in fact the payment. So a commercial vendor would need a payment in order to have that go ahead and be the case. And right now, the type of data that they store is usually on a subscription basis. And so there would need to be some sort of fund that the schools would pay into in some way in order for that to happen. So that could be something discussed. We did not yet contact BPPE. As Dean Clancy mentioned, it was on a potential sunset, and we probably would involve the committee, and it might even be helpful potentially, Dean Keller, to identify maybe 2 CSBARS members who might like to collaborate with the supportive staff to continue the research in this area.
Yes, that sounds good to me. I see Dean Park and Dean Clancy both had their hands up at that moment, which, you know, certainly seems to me would be a perfect fit given your background to continue exploring the BPPE if you're amenable.
I'm definitely open to it, whether I'm in the committee or not. We it's very relevant to school operations to track with Bepi. So happy to contribute.
And so would I, by the way. I have one comment related to what Dean Marshall said, and that is that it is a fact that the BPPE is always fighting for its existence. So we never know how long it's going to be around, which could provide motivation to us for coming up with a way to protect the records, the transcripts, without the BPP being involved. I said a while ago that it seems to me that since it's tasked with the responsibility by law, we ought to defer to that law or regulation and have them continue on. But Dean Marshall mentions another way to go, and maybe that is a good way to go when you consider the fact that that agency has come and gone over the years. The name changes just about every time it comes back into existence. But over the past, as I remember it, 20, 30 years, it's been in and out of existence a number of times. Could very well happen again. When it goes out of existence, it's sometimes out of existence for some time until the people decide at the Capitol building that, or before things change from one side to the other, that it's important to bring it back. But in the process, I don't know what would happen to the transcripts and the records that might have been accumulated at one point. And beyond that, as I said, I don't know that the BPPE is really doing it now. Maybe somewhat, but probably not much. My experience has been that they're not doing it. Thanks. And yes, again, I'd be glad to be involved in working with the BPPE.
Okay, thank you so much. I appreciate that. I did also, Dean Park, look back at kind of prior notes and what were some of the things that we were thinking of that kind of just were floated pre-research stage as potential places to hold on to transcripts or other student records. So I didn't do any substantive research beyond going next door to my registrar and saying, hey, someone mentioned, the transcript clearinghouse, and she explained her understanding was, they will pull transcripts from our record keeping and give them out to students, but they're not gonna, hold on to anything. And like LSAC or LSDAS, which are really the same one and the same entity, and that LSDAS is an old acronym for CAS, the Credential Assembly Service, which is part of ALSAC. So all of those acronyms are part of the same entity for applications to law school. So they will collect and store transcripts for people who are applying to law school, but according to some of my other colleagues, they're not aware of any way that they would store transcripts from law schools as opposed to passing on transcripts from applicants to the law schools to which they are applying. So I think that we probably have, eliminated a couple of ideas that we floated, but I think there's definitely more research to be done. And so if folks are interested, maybe we could look again at some of the listed items that were in the PowerPoint slide with 5 questions that we might research, and then after today's meeting, we can follow up with an email, putting folks in teams to take the lead on looking at these other items. So would it be possible, Natalie, to pull up the PowerPoint slide 3, just so we all have that in front of us?
Sure, I'm happy to do that.
Thanks. And while you're doing that, Dean Clancy, did you have another comment, or is your hand up from before? Thanks, just checking.
this is the slide you were
Yeah,
expecting?
yep, yes,
Right.
exactly. Number 3, that's it. Dean Clancy and Dean Park very graciously agreed to continue working on BPPE and coordinate with staff, perhaps to directly contact them. So that leaves looking at regional and institutional accreditors as I think a relatively small research point, exploring any other potential escrow options. I think Natalie just identified some of the related issues. If it's not LSAC, but some sort of commercial vendor, how would that work if you have a subscription and your school is closing, or there's the death of a key player and no one is paying the subscription, then that becomes a problem. So that would be something that have to be wrapped into thinking about. Point 2. Third point to think about is essentially, I think what helps raise this issue is a situation of a standalone school, because presumably schools that are connected to a university will be able to rely on that university to keep their records. Another big issue to me and my colleague next door, our registrar, is like, what would be an efficient way if law schools are asked to track whether students actually register with the bar within 90 days of enrollment. And then finally, another big picture question is, would it actually be feasible to share copies of ongoing student records with the state bar, whether that be periodically providing transcripts or even entire student records, which I think is increases by a magnitude of difficulty the burden on schools, particularly smaller unaccredited schools. So what I'd suggest is that we can start with this and come up with some teams to ask folks to address these particular points, or at least to take the lead on it. Certainly interested in everyone's input. But I think before I ask for further feedback on that, more threshold question is, should there be a number 6 or 6 or 7 on this list of things that we should be thinking about or researching? Yes, Dean Clancy.
I have an issue to add. This is a bit of an aside, and maybe it's not something that would seem relevant enough to everyone else that we ought to add it, but it's the fact that, or the comparison that the BPPE requires that records be kept for 5 years, or let me say it differently, 5 years worth of records, and transcripts, meaning transcripts forever, which seems very reasonable to me. But as I read the state bar rules, the responsibility of California law schools is to keep records forever. The wording in Rule 4.160A sub 11 talks about the schools must maintain complete and accurate records of its programs and operations. There's another sentence in that rule that talks about maintaining sufficient records from the last 2 periodic inspections, as well as transcripts, I think it is. But my point is that it seems to me that California law schools have to keep records forever. And I've complied with what I think the rule is by keeping records. We've had records for 41 years. We've got 41 years worth of student files. It would be much more reasonable, if I'm interpreting the rule correctly, it would be much more reasonable if it was modified, if it was changed to something like what the BPPE has in existence, which is a 5-year responsibility, except for transcripts, which is a responsibility to keep the transcripts forever. So that's my suggestion for item 6.
For what it's worth, I think that's a great point. And I think it's important to keep in mind the distinction between transcripts and other student records. So I think we could 6, when we're talking about length of record keeping, there might be a distinction between how long you have to keep all records versus how long you have to keep transcripts, because transcripts might, be important when someone who graduated a long time ago suddenly decides, to move back to California and take the bar, whereas probably less important to find some of their other records. All right, thank you for that, Dean Park. Anything else to add here?
Yes, I just wanted to echo on 6 that I think exploring this question is useful, because when it comes to what should a closing school provide to the state bar or to BEPI, it definitely will make the transfer and the preservation and the protection of the records that are being handed over different logistical size, depending on the outcome of 6. The other modification I have for 6 is length of student record keeping, because I know that in the rest of the rules and guidelines, of course, there are other institutional records to be maintained, but what we're talking about here, it's really related to what we're keeping per student. So just wanted to. And yes, I wanted to distinguish those because maybe there is a reason to differentiate. Thank you.
Okay, great. Okay, so yeah, agreed. I think our focus is very much on the preservation of student records in this discussion, not so much the other institutional record keeping that might be required. Dean Marshall.
Yeah, I'm just, again, thinking out loud along with some of the recent comments from Dean Clancy and Dean Parks about scope of records and length. I mean, it seems like length in perpetuity is an obligation of ours, especially with regards to the practice of law and the students who are either seeking to practice law or to move to another state or move back to California. And I think scope too, and I'm just throwing this out for discussion, but isn't that that scope, all of the student records become important from protecting the public side of things? What if there's something in a file, I'm hypothetical, student has graduated 30 years out and now wants to practice in a state, in another state. And in terms of what might be in that record when we get the application for moral character or a student investigation and or any other thing that might be relevant, do we not want to preserve those records? And do we not potentially have that duty and responsibility to the public, whether it's in Illinois or California? Again, I'm just thinking out loud.
Well, it's possible. I mean, part of the length of the record keeping is to allow the state bar to establish a trend over a 3 inspection period. And if the length of the time were shortened, perhaps the length of time between inspections would be correspondingly shortened as well. Another factor that we see is that in this school population versus the ABA approved population, we see more students that might occasionally be taking more time to take the bar exam. And so length of time that records are held might be especially relevant here, but more research could tell us more.
Okay, thanks, Dean Park.
I did want to mention in relation to that point, I notice out of the entities that speak to transcripts, the state bar has an especially, or had an especially lengthy description of what's required on transcripts. And sometimes even when I take that to different student information systems, they're surprised at the length of what needs to be documented, what type of incidents for a law school transcript. But I think if we are going to explore this question on number 6, I really do care about what Dean Marshall mentioned, but if any of those concerns related to a student's history being at a law school is captured within what's already regulated into the transcripts of law students by the state bar, then perhaps there's less of a pressure for it to be in a student file. And I also have student files from many years ago. It's certainly possible to pull the items from it, whether it's in print or digital, but is it efficient for a lot of that information to be kept that way and have to be reviewed that way to answer a question that could be otherwise captured in transcript? Would be just somewhat of a thought I would share back to the idea that I agree we need to care for consumer protection, but there are certainly ways to do it that may not involve keeping all of the student record, but instead making sure that the relevant information is user-friendly and accessible in one place.
So just to clarify that, if I'm hearing you correctly, one sort of initial point of consideration would be what's already on the transcripts per se, the unaccredited registered rules. And if material related to some of the issues that Dean Marshall raised is already on the transcript, then that would address some of those concerns.
Yes, thank you.
Great, thanks. Dean Clancy.
Yes, I just wanted to make a comment again about something mentioned by Dean Marshall. He talked about his interpretation of the state bar rules as indicating that we are obligated in perpetuity, as he said, to keep records. And that's my interpretation as well, though I guess it could be argued the other way, that it's just for 2 or 3 periods of periodic inspection. I think there, at the very least, there should be an effort to create some clarity on that difference of opinion as to how long it is that our schools need to be holding on to records. I would be elated if it turned out that the decision from the state bar is that, or that the guidance from the state bar is that it's only for 2 or 3 periods of inspection and not any longer. So at the very least, that would be something that would be good coming out of coverage of item 6.
And so part of what I'm hearing is that the referral from the committee really was focused on preserving records and making sure that things that students need would be preserved. And something I'm hearing is that something to bring back would be also, is there a time in which current records that are kept can be destroyed? And that might be a separate question that the CBE could determine the appropriate level of priority and also make sure there's clarity.
That would be great. Thank you.
Yeah, that is consistent with what I'm hearing, and for what it's worth, I definitely thought of those as kind of two separate things. Of one, records of programs, operations, student records versus records specific to CBE visits. So the fact that there's a timeline mentioned in one, not the others, to me, I didn't think that had any real crossover potential there, if that makes sense.
And so because we cannot have the committee have discussion offline outside of this forum, if people are not signing up for particular questions here, I'm not sure if Dean Clancy and Dean Park are so gracious as to tackle all of these questions at once, or if not, staff can send out the list of questions. We can get a list of expressed interest and then try to assign it based on that list of expressed interest for further discussion in this forum.
Yeah, so that's what I had in mind, that we would get this list down and then staff could solicit interest of folks on different topics if there is, if they have interest, and maybe folks are happy to take the lead on any particular one, since we'll all have the opportunity to discuss as a group at an upcoming meeting. And then we can, tackle sort of our position papers, if you will, along with any research that might be tied to a particular topic.
Okay, and then once we understand how many questions each team of two would be tackling, we can determine how much time might be needed, and then we'll be able to agendize for a future meeting.
That sounds good to me. Any other thoughts from folks? All right, that sounds like a plan.
Okay, Dean Keller, I think this is the final item on our agenda for today.
Yes, it is. There's no closed session. So I believe that means we are ready to adjourn.
Okay, thank you, everyone.
We need a vote to adjourn under the new rules, please.
Oh, I apologize. Thank you.
Thank you. I was wondering about that. So I was like, I was pausing for a long time. Thank you for jumping in.
No problem.
So do I need a motion to adjourn? Okay, do I have a motion to adjourn?
I would be happy to give the motion to adjourn. This is Dean Park.
Thank you. Do I have a second?
Second.
Dean Leal seconds the motion to adjourn. Do we need to do this by roll call?
Yes, because we are in a remote teleconference status, please.
Dean Clancy,
Aye.
Dean Leal,
I think you're muted.
Aye. Can you? sorry?
yes, thank you. Dean Marshall,
Aye.
Dean Park,
Aye.
Dr. Wilcoxon,
Aye.
and Dean Keller.
Aye. Okay, the motion passes. Thank you, everyone. And please keep an eye out for an email from staff related to this last item, and think about what item you might be just dying to work on, or if not, you are welcome to say you're open to tackle any of the items as one of the team members. Thank you so much. Have a great
Thank you.
day.
Thank
Bye-bye.
you.
Thank you.